Hello there, this is Leanne the lawyer, and I am here with part 2 of my series on criminal law. There will be 8 total videos in this series. This happens to be the second one, and this one is going to delve into the 2 essential elements of criminal law, mens rea and actus reus. So let's get started. So what are these 2 things? What are these 2 Latin terms? Well, let's look at a crime. In my first video, I talked about my fictitious neighbor, Jim, who had killed my goat. Now, when something like that happens, most crimes, and you'll see not all of them, but most crimes require you to go into what was the mental state. What was the defendant thinking? In this case, what was Jim thinking when he killed the goat? That would be very important to try to determine whether or not he acted, it was a crime, or what level of a crime it was, and so on. So let's pretend that Jim, prior to killing my goat, decided he wanted to take revenge on me because he knew I loved that goat. So he sat around, he plotted, he planned, and he decided he was going to stab my goat to death right in front of me. And that's what he did. Well, his actions and everything that he did can help us develop what his mental state was, right? And if that's one of the elements of the crime, that he had to have a malicious intent, then don't you think that he had a malicious intent in that scenario? Well, so far with the facts I've given you, it seems like that's where we were going with that. But what if Jim decided to kill the goat, and as we uncovered the facts, we determined that he had a goat that looked exactly like my goat, and we're neighbors. He saw the goat, thought it was his goat, and he killed the goat in a way that you would normally slaughter a goat for food because he was trying to get the meat from the goat. And then upon discovery that the goat was not his, he went to the authorities and he let them know, I made a mistake. You see how the mental state, the mens rea, is different in that situation than it was in the first one. So getting inside of the accused head, into their thoughts, is extremely important in criminal law. It oftentimes determines what degree of a crime that they are facing, or whether they're facing a crime at all. So that's what mens rea is. It's the general intent, oftentimes referred to as an evil mind. It's the mental element of a crime. Then we have something called actus reus, and as you can see from the word actus, it's the actual act that somebody takes. It should be a voluntary act. It's often called an evil act. It's the physical element of a crime. So in my 2 scenarios, it would be the action that Jim took to take the life of my goat. All right, so first thing we're going to do is we're going to look, the first half is we're going to look at mens rea. And then when we're done completely discussing mens rea, we're going to go into actus reus. So at common law, mens rea could be divided into a couple of different ways that you could establish intent. The first one would be, let's figure out what the general intent of this individual is, okay? This is where someone would have intended to do the thing, to take the act, but not the result of the act. Okay, this is where somebody has done something, but they didn't intend for the consequences to be so severe. A lot of times this would be, I'm in a fight at a bar, and I don't like this guy, and I just want him to stop talking, and I think to myself, I'm going to punch that guy in the nose. I don't have an intention to do anything more than to hurt his face with my fist. But somehow, some way, I'm superhuman and I hit him in the nose and his little nose bone goes right up into his brain and somehow I kill him. Ooh, well, I intended to punch him, right? I certainly didn't intend to kill him. So if we look at the general intent, it's you intending to do the act, but not necessarily intending the consequences or the final result or the outcome of the act. Now, specific intent is you did mean to do it. Okay? That is, you desire or you purpose to cause the result of the act. And that's where, hey, I want to kill this guy because I can't stand him. I think he deserves to die. I'm trying to kill him, and in fact, that's what I did. That would be specific intent. And even if I failed to kill him, I punched him as hard as I could. I wanted to kill that guy. That was my intent. But I failed to do so. I still attempted to kill him. That's still considered specific intent because I intended that crime to be committed, starting with my my mens rea, and then ending with my act that I took to accomplish that task. All right, then there's something called constructive intent. Now, under common law, this is where the result was not intended, but the act was very likely to cause the result. In this case, it's treated as specific intent. So let's go back to my goat. Jim, okay, sees my goat, and he takes my goat and he tosses my goat into a pond. Now he says he just was trying to see if the goat could swim. He really meant no harm. He was just trying to see if my goat could swim. But what if I told you that my goat only had 3 legs? It was very elderly. In fact, I mean, it was on its last of those 3 legs, if you know what I mean. And it was wearing a backpack full of rocks. And Jim still picked up my elderly 3-legged goat with a big backpack full of rocks, and he threw him into the middle of a pond. Now, he may not have intended for my goat to sink to the bottom of the pond and drown, which he did. He may not have intended that to happen, but the act, wasn't it very likely to cause the result? Yeah, it was. That is constructive intent under the common law. And we also have something called transferred intent. This is an unintended illegal act resulting from the intent to commit a crime. The original intent that the actor has transfers to the unintended result. Let's go back to my goat. In this particular instance, let's say Jim wants to kill my goat. He wants to kill my goat by drowning. Okay? So this is his intent, specific intent to kill my goat. Picks up my goat, my 3-legged elderly goat with a backpack, and he throws my goat into the middle of the pond. Now, what he doesn't know is there aren't rocks in that backpack. No, my friends, there are puppies. There's a litter of puppies in that backpack. Now, somehow my goat is able to wriggle free from the backpack, and he's somehow able to break the surface of the pond and get out of there. So, even though the goat was the intended victim of that crime, he didn't die. So he didn't get his intended result. But you know what he got instead? He got 5 dead puppies in a backpack. He didn't intend that. He didn't know they were there. But the evilness of his action, that intent, transferred over to the puppy victims. So in a court, we could charge him for the death of those puppies. That is where you're transferring his intent. His intended victim didn't expire, but those puppies sure did. And it was completely because of his actions and his evil intent to do something. So that would be transferred intent. Now, also at common law, and still a lot of this is today. We use this law today because it's been passed down in case law throughout the years. The common law divided your mental state into 2 different types of crimes. The first one is going to be malum in se. The second one is going to be malum prohibitum. Malum in se means of itself, okay? In and of itself. Malum in se means that crime is inherently evil. Everybody in every nation knows that this crime is illegal. Jurisdictions still recognize this distinction, and when they do, they require an evil intent for these crimes. They often say with malice, or, you have to have an evil state of mind to commit these inherently terrible crimes. Those things are like murder, rape, and arson. They just are inherently evil, the crime itself. Malum prohibitum, the crime isn't evil in and of itself. It's only criminal because it's been declared so by the legislature. Okay, these are things that you don't just say, yeah, it's really wrong to kill somebody, or it's really wrong, to burn somebody's house down. No, these are things that are only wrong because the legislature says they were wrong. They don't make you an evil person. You don't have to have an evil state of mind. And examples include things like failing to file your taxes. It doesn't make you an evil person because you failed to file your taxes, but you shouldn't do it. It's prohibited. That would be malum prohibitum. Also, failure to get a building permit is another example I have here. Just how jurisdictions operate within those 2 types of crimes. Now, there's also something called strict liability when we're talking about mens rea. These are crimes where you don't even actually have to have a mental state. You don't have to, it's just the act, you actually doing that crime, the state doesn't have to prove what your mental state was when you committed that. So this is where you're guilty of a criminal offense, even if you had no criminal intention. Strict liability crimes do not require any kind of criminal intent, and they usually involve like regulatory crimes, petty offenses, and infractions. Now, things like failing to get a building permit, they don't care why you didn't get the building permit, but you didn't get one. So all they have to show is that you didn't get the building permit. They don't need your mental state. You didn't have to be an evil person. So in that case, that's a strict liability crime. Either you had a building permit before you started building or you didn't. Same thing with speeding. Let's pretend your speedometer is broken and you're going 65 in a 45 zone, okay? All the officer has to show is that you were going 65 in a 45. He doesn't have to prove what your mental state was. I'm going to be so speedy today. He doesn't care about that. Nobody cares that your speedometer is broken. All they care about is that you were exceeding the speed limit. So you'll find these types of strict liability crimes in areas where it's not, where the actions aren't particularly egregious. Then there's something called vicarious liability. Another situation where you don't actually have to have the mental state because you are actually assuming responsibility. You are being held responsible and accountable for someone else's actions. This often happens in an employer-employee relationship. For example, if your employees are committing sex crimes against the workers, you didn't have to want to do any of that stuff, but certainly as an employer, you can be held accountable depending on the circumstances. So it's a complex area of law, but you understand the basic concept. You could be vicariously liable for the actions of your employees. So you have to keep an eye on these people. Also, a lot of times this comes up in the juvenile system. What if your kid isn't going to school? A lot of times the parents are held vicariously liable, and they will actually be punished as well as the child and through juvenile court. But the parents can be held responsible. They didn't want their kid to miss school, more than likely. They weren't trying to, but somehow they are still seeing some of that punishment. So that's the idea of being vicariously liable for someone else's crimes or their intent. Okay, so to the model penal code now. Now, I've talked about the model penal code in my other video, and I'll probably talk about it in all my videos because not everybody's maybe going to watch all 8 of these. The model penal code was developed by the American Law Institute. Now, I have to emphasize to you that when you see something referencing the model penal code, it is not actually law as it stands on its own. In order for it to become law, it needs to be adopted and enacted by a state legislature or by the federal government in order for it to become law. As it stands by itself, it is simply what the American Law Institute, the scholars at the American Law Institute, believed would be the ideal set of laws or principles to follow when it comes to criminal law. So they sat down and they said, what would be the perfect murder statute? What would be the perfect kidnapping statute? Those are things that are there for reference to state legislatures as they're writing new laws or as they're revisiting their existing laws. So let's see what the model penal code said. What is their ideal states of mind when it comes under mens rea? So first one's going to be purposeful. This is, hey, you did it on purpose. This is most commonly equates to the common law specific intent that I talked about. The result must be intentionally desired. You want this thing to happen. Now, under knowing, which is slightly different, the actor must be aware of the nature of the act. He must be practically certain, near 100%, that the conduct will cause the result. Now, he isn't taking the act in order to cause the result in this situation. He's taking the act, but he's pretty darn sure that when he does that thing, it's going to cause a certain result. He has to be close to 100%. This is Jim throwing my elderly 3-legged goat with a backpack full of rocks into a pond. Does he really think that the goat is going to come out of that alive? He should be close to near 100%. He should know. or he should know that that action that he took was going to result in the death of the goat. Now, reckless is something a little bit different. It's less than knowing. This is where someone consciously disregards a substantial and unjustifiable risk that the result will occur. So let's take the backpack off of my goat. Let's give him back his other leg. Maybe he's just elderly. So he's not at any kind of a disadvantage, okay? And Jim thinks it'd be funny to throw him into the water. Now, unfortunately, my goat drowns in that situation. Now, he knew that that was a possibility. He wasn't near 100% certain that the goat would drown. But he knew, didn't he? And he consciously disregarded the risk to the goat by taking that action. That's somebody who's just plain reckless. You see this sometimes in situations where it's unfortunate, like in these hazing incidences on college campuses, where people are having, someone else drink a large amount of alcohol. They know that alcohol poisoning is a thing, but they consciously disregard it because they just don't think it's going to happen. They're just being very reckless with someone else's life, okay? And in that situation, that's a reckless situation. It could rise to the level of knowing in that situation, these hazing incidences. I'm not saying that they don't rise to the level of knowing, but there could be factors. You have to look at all the facts and the variables to see where you fell in that range. Then there's just negligence, okay? You're not consciously aware of the risk when, you did something. Your action, however, is a gross deviation from what a law-abiding person would do in that situation. A lot of times this is like texting and driving. A lot of people think, oh, if I just text for a second, if I just look down for a second, everything should be okay. They're not trying to run over a person, but then they do. And they're really upset about it. And that could be reckless depending on how much texting they were doing, were they going 75 miles an hour when they were texting? Were they at a stop sign and rolling out of the stop sign as they were texting? It just depends on a lot of different circumstances, but there's these nuanced levels. So you go from negligent to reckless to knowing to purposeful. Now, I keep talking about the situation and the circumstances, which transitions us beautifully into this slide. How do you prove what was going on in somebody's head? The subjective intent refers to, this is what the person actually intended. It's their motives, their intentions, their desires. And the way a judge or a jury, a fact finder, could determine because a lot of times the defendant is not going to tell you what they were thinking when they took that action. You're going to have to build that from the facts, from the circumstances, from the behavior of this person, and you're going to have to look at it and try to determine what that defendant actually intended. And you can build that motive as something else that you can look to try to determine what this person was thinking. Then there's something called objective intent. This isn't the defendant's actual intent, but you are replacing the defendant's actual intent with a legal standard. It's a legal imposition of what the defendant should have known or believed. What would a reasonable person have known or should have known in that situation? My poor goat with the backpack full of rocks and with the 3 legs, and he was elderly. I mean, what would a reasonable person think in that situation? What would they have known? What should they have known before throwing the goat into the water? What did you think was going to happen? That's the objective intent. That's where you take a reasonable person's thought processes. You put them onto the defendant because you can't really get into the defendant's head. Some other ways that you can prove what was the mental state, okay, as you're thinking about this person's mental state, is you can look at inferences. These are conclusions that a judges or juries are permitted to make after considering the facts of the case. You can look at all the facts, and the judge may give you an instruction that says, based on the evidence, if you find that, the goat had a very little opportunity of being able to swim on his own, then you can infer from those facts that the defendant was being reckless. Okay? That's one thing, is and the jury doesn't have to find that inference, but they can. They are permitted to do so. Then there's something called a presumption. This is a conclusion that must be made by the judge or the jury. There's two different types. Okay, so the inference is permissible. You can or cannot go with that inference depending on your evaluation of the facts. But a presumption is something that's just there. And it's either rebuttable or it's an irrebuttable presumption. A rebuttable presumption is a conclusion. You have to draw the conclusion, the presumption. But then if the facts disprove that, then it's rebuttable and you can throw it out. And the greatest example, the one that we're all familiar with, is the presumption of innocence. So in this case, somebody is presumed innocent unless and until they are proven guilty, right? So the presumption you have to go with is that the defendant is innocent. And you have to think that until the facts show you otherwise. And then you're allowed to rebut that presumption. Now, an irrebuttable presumption, and some people argue the constitutionality of irrebuttable presumptions, but if this is regardless of what the evidence shows, an irrebuttable presumption stands as a fact. So this is something that the judge and the jury, the instruction is, you have to presume this, you have to believe this, even if the facts show something else. And that's called an irrebuttable presumption. Looking at motive. So we talked about earlier in the video where Jim was sitting around plotting how is he going to take revenge on me, okay? Motive is the reason why a person does something. Why did you do it? Did you do it because you were trying to take revenge on me, or did you do it because you made a mistake, thought it was your goat, and you just wanted the meat? Big difference, right? That motive helps us understand the mental state of the individual. So that's why the motive leads us to mens rea. Now, motive is not an element of a crime. Why somebody did something is not one of the elements of murder. Why somebody did something is not one of the mental state is an element, but why that person, that just helps you understand mental state. But where it comes into play is sentencing. So if somebody really had a really terrible, evil motive, that's going to perhaps enhance the sentence for that person, and it may actually reduce the sentence if it's found later, during sentencing, that this person really didn't have an evil intent. All right, so moving on to actus reus. So we talked a lot about, actions and mental state together because they do work together. Somebody taking an action, what was their mental state leading to that action? Now, in actus reus, it has to be something voluntary. Okay? In order for you to be criminally liable for something, you have to actually have voluntarily taken that act. So there's reasons why you might not be voluntarily doing something. So the Model Penal Code says these are the things, that kind of outline the different circumstances where you might be doing something involuntarily. Let's say your reflexes, or you have a convulsion while you're driving. Are you responsible for, the people that you run over when that happens? You weren't taking a voluntary act. It's going to completely change the circumstances of the crime that you may be charged with, or whether you'll be charged at all. Bodily movements that you may take during unconsciousness or sleep. You might punch somebody in your sleep. Are you liable for that? What about conduct during hypnosis or resulting from hypnotic suggestion? So there's it says, if somebody's under the influence of hypnosis, are they really responsible for their actions? And any other movements that are not a product of the effort or determination of that actor. Okay? It's not something that you purposely and voluntarily did. Okay, so let's talk about some different things that you could do. Well, one long-standing proposition is that thoughts are not enough to constitute actus reus. So just thinking about something doesn't really do anything. For example, Jim could have been sitting around all day long, for weeks, for months, for years, thinking to himself, gee, I'd really like to kill my neighbor's goat. But he never acted upon that thought. Just having an evil thought alone is not enough to constitute actus reus. It is not enough to be a voluntary act. Also, statements. Statements can be acts, but there's a really big impediment to saying that statements are acts in that we have something called the First Amendment. It protects freedom of speech. There are limits to this protection, however, and some examples include inciting a riot. If you're saying things that are causing a riot to ensue, that is not protected speech, and it is actually an act. Something like treason, solicitation, conspiracy. All of these things can involve statements that can be construed as voluntary acts to meet that actus reus requirement. Also, anything that's going to cause imminent harm to others if you're talking about statements as an act. All right, what about your personal status, who you are? Is that an act, just being who you are? Well, things such as your illness, a financial status, race, sex, religion, these are all examples of human conditions, and they cannot be declared criminal. You just can't be declared criminal just because you are something. Now, personal status may not be criminalized, but it may be subject to the regulatory authority of the state. For example, people who are mentally ill and who pose a danger to themselves or others may be civilly committed. And that's for obvious reasons. It's there to protect the individual from himself or herself, and it's also to protect society from perhaps a person who is going to do something dangerous. Okay, so who you are specifically is not an act all by itself. How about possession as an act? This is just having something. Okay? Now, obviously, you've all heard of possession as a crime, so this shouldn't be a big surprise to you. Certain items can be made criminal. For example, drugs, narcotics, contraband, anything that you would have to sort of make or use a drug. Some contraband is perfectly legal, and some of it is not. And having certain types of dangerous weapons could be considered an act. Possessing that thing, maybe you're not supposed to have a gun. Something has happened and you have lost your right to have a gun under some other statute. Just merely having it, the possession of it, is an act. Now, the Model Penal Code talks about how an act of possession can be either actual or constructive. Possession is an act as long as the possessor knowingly procured or received the thing possessed. It's like you knew that you were getting that thing, or you knew that you were receiving that thing. Right there, that's enough to constitute possession. Also, if you became aware of your control of this object or item for a sufficient period of time to have been able to terminate your possession of it. Let's pretend that your roommate has put drugs in your room and you didn't know anything about it, but it was there long enough for you to have discovered it. The police could make an argument that you were in possession of the narcotics. It was there long enough for you to know about it, and you could have disposed of it and gotten rid of it, knowing, oh, wait, I shouldn't have this thing. How about when you don't do something? Is that considered an act? Well, we talk about this word is called omissions. Failing to do something that you should do. Just you not doing it is an act. The act of not doing it. So sometimes your duty is imposed by statute. For example, leaving the scene of an accident. So if you go and you get into a car accident, many states have determined that if you leave the scene of that accident, you are omitting an action that you should be taking. If you fail to stay at the scene of the accident, then you are committing a crime. That duty has been imposed on you by statute to do something once something else has occurred. How about duty by relationship? Parents, you have to take care of your children. You have a duty, you have a responsibility to take care of your children. You have a duty, responsibility not to do things to your children, like abuse them, okay? Also spouse to spouse. So sometimes this duty to do something is created by the mere relationship that you have with another individual. So that is very important. And if you fail to do that thing, then that can be considered enough to be actus reus. You can also have a duty which is established by contract. This is, for example, like a physician and patient. A physician has an obligation to do no harm. A physician has a contractual duty with the patient to make sure that the physician takes care of the patient and helps the patient in whatever way they possibly can. Same thing with a lifeguard. When you go to a public pool, the lifeguard, there's an expectation, a contractual expectation that that lifeguard will act to save you if you start to drown in the pool. Now, what if you're not a lifeguard? Well, maybe you assumed a duty. For example, you might voluntarily take on the duty to take care of your children, your friends' children at the pool. You say, oh, don't worry, you go have lunch, I'll watch your child. Well, now you've assumed that duty to take care of that child should something happen to the child at the pool. Now you're going to be on the hook if you fail to do something, if that child becomes, starts to drown or something happens to the child. You've assumed that duty. Also, if you see a complete stranger, normally there's no duty imposed upon you if you are walking by a lake and you see somebody drowning. You do not have to jump in and save that person. I know that sounds awful, but it's the truth. However, if you decide that you are now going to go in and try to save that individual, you are assuming the duty to rescue. You make movements towards saving that person. You jump into the water and you start going towards that person. That act in itself, you've now assumed the duty to rescue. Others may not act because they see you acting and they're thinking, oh, I was going to jump in and save that guy, but that other person is doing it. I don't want to get in the way. But then you decide, no, the water's too cold. I don't want to go. I don't want to swim out there. And you turn back. In the meantime, that has delayed other people making an effort to rescue that person. So you could be on the hook for failing to continue that assumed duty to rescue. What if you have in fact created some sort of danger? Well, when you create a danger, you may be taking on a duty to help those that have been placed in danger because of your actions. For example, an arsonist has a duty to rescue those in the fire. A lot of people don't realize that. What if an electrician is working on a home and he starts a fire? He's like, oh, well, I think I'm just going to go on my lunch break now, and doesn't warn the people in the house. Well, he's going to be on the hook for omitting to warn or save the inhabitants of that house. Now we look at causation. Okay, so we have these voluntary acts. We understand what an act is. So there are two forms of causation that exist in criminal law. There's factual causation and there's legal causation. Now, factual causation is pretty simple to understand. It's sort of this domino effect. If you think about it, an act is the cause and fact of the result. If the result would not have occurred unless the act occurred first. This is the but-for analysis. So but for the act of the person, that harm would not have resulted. So for example, when we go back to the goat situation, the goat drowned and Jim picked up my goat and threw him in the pond. Now, even though he didn't intend for my goat to drown in one scenario, he just wanted to see if the goat could swim, his action led to the death of my goat. So that would be, he's the cause in fact of the death of my goat, because but for his action of picking up my goat and throwing him into the pond, my goat might still be alive. So factual cause means that the defendant started a chain of events. Legal cause means that the defendant can be held criminally responsible for the harm because the harm is a foreseeable result of the defendant's criminal act. So in the situation I just mentioned, we've got my neighbor Jim. He picks up my goat. He throws him in the pond. My goat dies. Very simple. There's not a chain of events there. So he's the legal cause of the death of my goat. He's also the factual cause of the death of my goat. Factual cause because but for his actions, my goat would still be alive. Legal cause, okay, because he's going to be held criminally responsible for the harm that befell my poor goat because it was foreseeable. But what if, okay, we have an intervening cause, okay? So let's imagine that my goat, who he threw in the water, I jump in, I rescue my goat. I get my goat. I call the veterinarian ambulance. The veterinarian ambulance pulls up. They put my goat in the ambulance, and they start to drive away, and they're in a terrible accident. They crash. My goat was going to survive, by the way. They crash, and then it burns up, and everybody dies in flames. Now, but for Jim's act of throwing my goat in the pond, my goat would never have been in that ambulance, okay? So that means that he is the factual cause of the death of my goat because he started that chain of events. But legally, is he the cause of death of my goat? Or is whatever caused that ambulance to run off the road, is that the legal cause of the death? Because the goat didn't die by drowning. He died by fire. He died by ambulance accident. So there's a question there. So legal cause, the result, must be a consequence of the act, not some kind of coincidence. And the Model Penal Code uses the phrase, it can't be too remote or accidental. There has to be some similarity between the intended result and the actual result. So you have to look at that. This is going to be something for the jury to determine, the fact finder, the judge. So an intervening cause, like I just mentioned, where this whole ambulance thing came about, it's common for legal cause to be lacking when there's a happening that occurs after the initial act and it changes the outcome of events. Okay? So, and then for factual cause, we already stated it's the whole but for analysis. Also, with the voluntary act in Actus Reus, there are some crimes that require both a mental state, a mens rea, as an element, and a physical element in Actus Reus as an element. If that is the case, then both of them must be present, and it must abide by what is called concurrence. This is the joining of the mens rea and the Actus Reus in the act. The mental state must occur first and send into motion the act. There has to be some sort of a connection between the two things. So Jim gets this crazy idea that he's going to kill my goat, and then he takes some action in furtherance of killing the goat. There's this concurrence. There has to be some sort of connection between the two. It can't just be like Jim gets this crazy idea that he's going to kill my goat, and then all of a sudden my goat gets struck by lightning. That's just a coincidence. There's no concurrence there. He didn't actually take any act. He was just thinking about killing my goat, and he's very happy that the lightning struck my goat, but he's not going to be legally on the hook for it. All right, I want to thank you for listening to this lecture. I appreciate it. If you liked it, please like it. If you'd like to hear more about my videos and when they are made available, please subscribe and get some notifications. All right, thank you.